So yesterday we talked of how to draft a plant, and I told you various things regarding drafting of the pleading. Uh, I have given you a page just to look into in app that what are the different contents of a plant. I have sent this page in your app where you can see what is the plant structure. I hope you have understood this in yesterday's class, but just for your clarification, the first is heading and title. Can you see this plant structure, heading and title? Now you can see this the court name, the suit number, the plaintiff's name and address and identifiable characteristic, similarly of defendant, no? Then description of the suit. Then the description of the suit. So if you see carefully heading of the plaint, you find that it has a name of court. I am just reiterating this. Heading of the plaint means the court in which suit is instituted. Heading of the plaint. Then comes suit number. Then comes name of the parties. Plaintiff and defendant. Plaintiffs and defendants, if there are many plaintiffs and defendant. And then comes title of the suit. This is suit for what? This is suit for what? I will recommend you to see the various performas which are available in general. Is this clear? This is given in this also. This is the thing. Name of the court as the top. No? Then it is suit number and here. Thereafter the name of the parties. Can you see this? Plaintiff and defendant. If it is individual person, then they say, if it is proprietary concern, then proprietor of this, then partnership firm. So whatever is the party, it may be an individual, it may be a proprietary firm, it may be a partnership firm, it may be a company, it may be a statutory corporation, it may be municipality, whatever. There can be various kinds of plaintiff and defendant. Body of the plaint, this is the second thing. Body of the plaint. Second is body of the plaint. Now what are there in the body of the plaint? You just see carefully substantive portion, and Moga in law pleading has divided the plaint into two parts, substantive and formal. Substantive and formal, there are two parts in the body of the plaint. What are there in the body and what are there in the formal plaint? Is this clear? These are the two things. Body of the plaint, substantive portion, and then the other portion is formal portion. That is what I have given in your page. Substantive portion says, this is basically two kind of things are there. All facts constituting cause of action. Now certain people could not appreciate cause of action, they will appreciate it today. Everything will take time. All facts constituting cause of action. Cause of action. And facts showing the defendant's interest and liability. How defendant is involved in that. भाई दो चीजें देखो, अभी तक जो मैंने बताई, कल कुछ लोग बोल रहे थे हिंदी में भी बोल दीजिएगा, तो मैं उनकी सुविधा के लिए बोल रहा हूं। सबसे पहला पार्ट आपने देखा हेडिंग एंड टाइटल। हेडिंग एंड टाइटल में हमने आपको चार बातें बता दी कि सबसे पहले नेम ऑफ द कोर्ट है, नेम ऑफ द कोर्ट, name of the court. Is this clear? सबसे पहले name of the court आ गया. Is this clear? At the top, heading of the plaint means the court in which the suit is instituted, Order 7, Rule 1, Sub Rule A. Then comes the suit number. तो दूसरा हो गया suit number, यानी वाद संख्या जिसको आप कहते हैं. तीसरा आपने प्लेंटिफ और डिफेंडेंट के नाम और उनके एड्रेस और डिस्क्रिप्शन लिखा. एंड चौथे में डिस्क्रिप्शन ऑफ द सूट है, टाइटल ऑफ द सूट, किस चीज का सूट है. सूट फॉर रिकवरी ऑफ मनी, सूट फॉर पार्टीशन, व्हाट इज दिस सूट ऑल अबाउट. सो यू आर राइटिंग दैट. सो चार बातें आपने हेडिंग एंड टाइटल में लिखी. कोर्ट का नाम सबसे पहले लिखा, सूट नंबर दूसरा, सूट नंबर ऑब्वियसली कोर्ट द्वारा अलॉट होगा आपको, तो सूट नंबर उसमें आएगा. ऑल राइट. एंड देन द थर्ड प्लेंटिफ एंड डिफेंडेंट, एंड देन द फोर्थ द टाइटल ऑफ द सूट, किस चीज का सूट है. Now this is the first part where it is heading and title. I have already spoken in English. The second part comes body of the plaint, substantive portion and formal portion. In substantive portion you are writing cause of action on the basis of which plaintiff claims the relief, and also the defendant's interest and liability. Because unless and until you show the defendant's interest and liability, you cannot make out a case for yourself. So that is necessary part. So that is what is substantive, and that is why it is substantive. Then this is formal portion. अब formal portion में क्या क्या आएगा? What is this formal portion? Substantive portion and formal portion. Substantive portion and formal portion. Formal portion में क्या क्या है? The date when cause of action arose. I have told you time and again, so I think that you will be appreciating this. A statement of facts pertaining to jurisdiction, related to jurisdiction. A statement as to valuation. And court fee. A statement as to minority or insanity. Then the fifth one is limitation. If you are claiming exemption of limitation, that has to be mentioned. Then it says relief. And then signature and verification. So these are two parts, substantive and formal. Obviously you can appreciate that the substantive will have more impact, because if you do not disclose the cause of action, and if there is no cause of action in your plaint, then your suit is or plaint is liable to be rejected as per Order 7, Rule 11, 1A. That's very clear. That's very clear. If there is no cause of action, how can you proceed further? There should be cause of action. Cause of action बहुत simple सा term है, अभी मैं आपको समझाऊंगा. I spoke even yesterday that car accident and injury to body, some people started questioning that because perhaps they do not have clarity on that. Cause of action is basically bundle of facts on the basis of which you basically pray for a claim. So in car accident, the damage to car has different kind of fact situation, and the injury to body has a different kind of fact situation. In injury to body, obviously you will show which part of body was injured and how it happened, and in damage to car you will again show that which part of your property is damaged and how much damage is there. So that is property damage and this is body damage. So they are two different fact situation. So that should not be mixed at all. It's very clear. So substantive part में सारे facts दिखाने on the basis of which you are claiming cause of action, and on the basis of which you are showing defendant's interest and liability, whereas in formal part all other necessary details are written. So these are the two parts of the body. Now here a very important question has arisen. We are saying again and again, material fact. Again and again we are using this term material fact. The question may come up in your mind, what is this material fact all about? What do we mean by material fact? Now it's very simple. If I claim a relief on the basis of sale deed, suppose, I say that I am A plaintiff and I have purchased the property from B, or B has sold me the property Y day a sale deed. Y day a sale deed annexed here as annexure A, dated such and such, which has been registered in court, then in that case, this fact of registration of sale deed and the fact of that person selling the property to me is basically material fact. It's a material fact. It's a material fact. It is substantive portion of the body of the plaint. It is substantive portion of the body of the plaint, without which you cannot make a proper claim. Because your claim is based on sale deed. You are saying that the property has been purchased by you and that is how you have got right over this property, which has not been given to you right now. You have not been given possession of the property or something like that. Or somebody is questioning your authority later on, so you will bring sale deed and you will say that I have become owner, why did this registered sale deed which has been executed by such and such person. So you will show the sale deed, and that is what is basically substantive, and this is what is material. So what is material fact? If a question is asked, I will quote certain things before you, material facts, you just write down. There are certain decisions also on this point. What do you mean by material fact? Which facts can be called material fact? Which facts is material fact? Which fact is material fact? So see, there is a decision of Supreme Court on these points. What is material fact? I am framing the question and I am answering them. This is Union of India versus Sitaram. The answer is Union of India versus Sitaram, 1977. SCR, Supreme Court Reporter 1, page 950. It says, all facts upon which the plaintiff's cause of action or defendant's defense depends. All facts upon which plaintiff's cause of action this is also material, and defendant will write his WS, that is written a statement in answer to your claim. So in his case it says, or defendant's defense. Or defendant's defense depends. All facts upon which plaintiff's cause of action or defendant's defense depends are material facts. Are material facts. This is one case. You are not required to memorize the name of cases, not at all. This is not to be memorized. This is just for your understanding that I have told you that Supreme Court ने इस case में ऐसा कहा. Supreme Court has said so in such case. Because in law you are required to quote from where you are quoting this law, either from a statutory provision or from a court decision. So that is why it is a necessity to quote such things when you go to court of law. But it is not necessary in your answer writing that every time you write a fact or you write a statement you quote a case. It is not possible, not plausible, not desirable and not reasonable. You should be very clear in your mind. Sir ने इतने केस लिख दिए, आप सबको याद कर जाओ. That is why I told you, you have to be in class from the very beginning, so that you can understand what I am trying to do. Even then, many people have not come to the class till this point. That's their discretion. Now then, another decision of Supreme Court. Birendranath versus Satpal Singh. I hope you can read my writing very clearly. 2007, 3 SCC, Supreme Court cases, page 617. I know that, I hope that you know this. This is year 2007. This is third volume of Supreme Court cases, and this is page number 617. So if you go in 2007 SCC cases, you look into third volume, and then you see this page, you will find it there. Is this clear? This is how citation is written. Now it says, material facts may be said to be those facts upon which a party relies for cause of action or defense. Defense is written both way, S, E and C. In other words, the material facts are facts upon which the plaintiff's cause of action or defendant's depends. What particulars could be said to material fact would depend upon the fact of each case, and no universal application can be let down. Therefore, in the light of above cases, it is evident that omission to state material fact renders the pleading defective. And if material facts are not pleaded, if material facts are not pleaded, then the pleading is considered defective. Now, if in such a situation where you have not been able to see, the whole purpose of this procedural law is to deliver justice. So, our approach is not of obstruction and destruction. Our approach is of construction. Our approach is of allowance. Our approach is to allow the plaintiff to bring out his case basically before the court for proper judgment by the court. So, what is the remedy in such a case? If there is no material fact which is there in your pleading, then the remedy is by way of amendment of pleading. So, if you have not been able to plead this, there is omission to state material facts. If a question comes before you as a judge or as a lawyer, that there is omission to state material facts, because see, in India, literacy is little less, the legal literacy is even lesser. So there may be situation where some people in far remote areas, where they are not exposed to such kind of legal acumen and knowledge, they might draft a pleading or plaint which may not be consisting of material facts, And now he realizes that he has not been able to do so. There is some defect, there is some lacuna. Will you give him opportunity to correct the error or not? To mend his ways or not? The answer is obviously yes. Procedural laws are handmaid to justice. So what is the remedy available if there is omission to state material fact? So I will say, now this case is over. So you frame a question. Omission to state material facts. A remedy or relief. What is remedy or relief? What is the remedy or relief in such a situation? So you will say the remedy lies in the form of, so you write down pleadings need to be amended. Under Order 6, Rule 70. We'll see how amendment of pleading is allowed, and when it is allowed. It can be allowed to both parties, plaintiff and defendant, because they have to file the pleading. Pleadings will come from both sides, plaint and written statement. Plaint and written statement. Is this clear? Is this clear? And now this pleading of material fact is important also for the reason I said yesterday, that you have to draft your plaint in such a way that you can adduce all relevant evidence before the court. If you do not plead a fact before court in the plaint, then you will not be allowed to adduce evidence regarding that. So this is the biggest disadvantage which a plaintiff may have. So it is necessary for plaintiff to draft a plaint in such a way so that it should be able to contain all material facts, and regarding proving of those facts, evidence can be adduced. You cannot be allowed to bring an evidence on a fact which you never pleaded before the court. You cannot be allowed to bring evidence on the fact which you have not pleaded before the court. So it is a genuine general suggestion. It is question of your legal acumen, that you should be able to draft your plaint in such a way to bring out all material facts necessary to show the cause of action to the court. And when you are required to prove cause of action, you will prove all those material facts. And for proving all those material facts, you will be allowed to bring evidence to prove those facts. If you do not plead facts, you will not be allowed to bring evidence to prove that not pleaded fact. So the fact which you plead, only then you can bring evidence to prove that fact. If you have never pleaded the fact, you cannot bring evidence to plead that fact. So that is another thing which is to be taken care of in writing of the plaint. Amendment of pleading is a separate topic which we will be discussing little later. Now, so you are clear on the fact what you should plead. You should plead facts, not evidence. Evidence you will bring later on. Evidence will be brought later on to prove those facts which is there in your plaint, which is there in your pleading. Evidence तो बाद में आप लाएंगे जो आपके pleading में उनको साबित करने के लिए. What facts should be pleaded and what not? You are clear. Material facts should be pleaded, immaterial facts should not be pleaded. So you plead material facts. Why you should plead material facts? To show cause of action. Why you should plead material facts? To bring evidence on those facts. If you bring immaterial facts, then the value of material facts also diminishes, and court will also have to now inquire even further and better to dissect between material and immaterial. It will waste time of the court, it will waste your energy also. So this is advisable that to save the time of the court, to save the parties of the suit, and to save the resources of the court, it is necessary, or of the system, that you plead only material facts, you do not plead immaterial facts. Why you should plead material facts? Because it will be possible for you to show cause of action, and it will be possible for you to bring evidence on those points. So you should not plead immaterial facts. I have already said you are not required to plead law. Now you may raise a question, why should I not plead the law? In writ petition, the law is different. In writ petition, you are required to bring the facts, you are required to bring the evidence, and you are required to tell the court law also. In writ petition, like in Article 226 of Constitution, it has a different kind of drafting. But here in plaint drafting, you are not required to plead even law and evidence. Why you should not be pleading the law? Now it is the duty of the court. It is the duty of the court to apply the correct law on that point. It is the duty of court to find the law. Obviously, the lawyers of both parties will help the court because they have to prove their averments. They have to prove their point. So they will obviously bring judgments, they will obviously bring statutes in their favor. That's a different story. But it is the duty of court also to know the law and to apply the law. So it is the duty of court to find the law. Obviously lawyers of both sides will support the court, will help the court to find the law. And that is why the requirement of pleading is plead only material fact, not evidence. Evidence will come at trial stage, that is very, very clear. And then the second point, that law should be now found by the court and not by the plaintiff. So that is why it is not required. I hope you have read about this even earlier, but I have made the points even further clear. Is this clear? I have made this point further clear. So now, once you are done with drafting of the plaint, once you understand how the plaint should be drafted, obviously it's a question of practice. We'll do certain practice after some time, not necessarily at the outset, because you have to be little bit sync with the subject. You have little bit awareness of the things of the CPC, then you can plunge into this kind of exercise. But you can do on your own, that there is no harm in doing it, but you require little bit maturity. Now moving further, after plaint is presented, after you have drafted the plaint, obviously you will present the plaint. Obviously in presentation of plaint you are required to inform yourself about various laws, which cannot be done in one day. We'll understand it little later, how the law will come in picture. But obviously you should know about, see, as jurisdiction is concerned. So obviously jurisdiction question is there in section 15 to 20, territorial jurisdiction. So you are required to see the territorial jurisdiction, particularly in 16 to 20. 15 is that you are required to visit the court of lowest instance. It is always a general rule that you should approach the lowest authority first. Some people will approach the highest authority first. That's their discretion. But the law says, and general common sense says, that you should approach the lowest authority because it is easier to get solution there. If you reach to higher authority, he has vast jurisdiction, so your term may come later on. So please, now keep this in mind, whether it is in criminal law, whether it is in civil law, or whether it is in real life. Even when you go to court for getting this FIR laws registered, the court will ask you, why did you not go to police? So you are required to now show the fact that you visited the concerned Thana in charge, he did not register your case, then you visited the concerned superintendent of police, even he did not order for registration of FIR, and then finally you have come to the court for order of registration of FIR in 156 of section 3 of CRPC. Here also in CPC at various places you will find such situation. If you are asked a question where you should go for execution, lowest court, the local court. In criminal law also where you should go for jurisdiction of the court, lowest court. Here also section 15 says. So you are required to see the lowest court. So for plaint presentation you are required to know the territorial jurisdiction. You are required to know the pecuniary jurisdiction. You are required to have idea of limitation. You are required to have idea of valuation of suit. You are required to have idea of court fee. So various things are there. That is what is called now advocacy skills. Obviously I am not teaching you advocacy skills. This course is not designed to make you advocate. This course is designed to get you so much of information in such a way that you should be able to pass the examination of judiciary. My purpose is not to train you for advocacy skill, but obviously you will learn many things which will help you enormously in advocacy as well. Because an advocate without information of law, without proper knowledge of law, cannot apply the law perfectly. So you should know the law, you should know the nuances of law, you should know the nitty-gritty of law. तो ये जो वेदिक की समझ आप इस क्लास में लेंगे, वो आपके अधिवक्ता बनने में, आपके वकालत करने में और आपके न्याय निर्धारण करने में हर जगह सहायक होगा. इसमें कोई भी अतिशयोक्ति नहीं है. सो आप यदि ध्यान से पढ़ेंगे तो आप CPC को समझेंगे, आपको ये एडवोकेसी में भी हेल्प करेगा, जुडिशरी में भी हेल्प करेगा, बिकॉज देखो अभी बताया आपको, ए जज इज रिक्वायर्ड टू नो द लॉ एंड इट इज द ड्यूटी ऑफ कोर्ट टू अप्लाई द करेक्ट लॉ इन करेक्ट फैक्ट सिचुएशन. सो एज ए जज इफ यू डू नॉट हैव अवेयरनेस ऑफ लॉ, दो the judgment will be cited before you, provisions of law will be brought before you, and then only you will give judgment as an umpire. It is not your duty to go and find laws, but obviously as an agile, as an alert, as an intelligent judge, you should not be misled by the lawyer's tactics. In many a situation, a judge is misled by lawyer's tactics. So it is always better for a judge also that he should know what is the law on the point. He may not know exact execution of law because he is a judge, he is not a lawyer. So now let us proceed further. Once this plaint is drafted and filed before the court, then the second stage comes. Now either this plaint will be admitted, or this plaint will be returned, or this plaint will be rejected. If everything is proper and fine, you will admit the plaint and you will initiate the further process. If I ask you as a common sense individual that if a plaint is filed, I have gone to your court as a plaintiff to seek a relief on the basis of cause of action which is reflected in my pleadings, what will you do? So if you see that there is a cause of action, if you see that this plaintiff has a case prima facie, will you not proceed further? The answer is obviously yes. But if you fail to find a case in my plaint, either it is not a civil suit, or it is not able to disclose a cause of action, or it is barred by any other law, will you accept my plaint? The answer is no. You will, in a case, reject my plaint or return my plaint to the proper court. So once the plaint is brought before the system, then there can be admission of the plaint, there can be a return of the plaint, or there can be a rejection of the plaint. Now see, you are not required to memorize anything. Many people, many of you, see, this learning of law is basically a quest in journey of learning the law in proper perspective. This is what we lack generally, without any iota of doubt, I can tell you. Because I was also a student of great university, Central University. But CPC was taught in a pathetic manner. I don't know what is the situation today, but we could not have a teacher of CPC properly in our university. That was very sad affair. And I remember I passed CPC paper only on the basis of reading of section 2 and section 80 of CPC. So this is the state of affair. So you should not be misled, you should not be carried away, you should listen to me carefully, you should understand the process of this civil procedure, and I hope and submit that you will understand maximum things, more than maximum. If there is any confusion or doubt here and there, we will try to remove that even now in the coming days. You should not worry about that at all, but just a sincere suggestion, please listen to me carefully. And it's a very common sense story which I am sharing with you. I said you on the very first day that I will be sharing a story rather than teaching. So I said, plaint aa gaya, ab kya karoge batao? अब आप प्लेंट का क्या करोगे बताओ? आप क्या करोगे प्लेंट का बताओ? So either you will admit the plaint, return the plaint, reject the plaint. Now admit the plaint and start process, return the plaint and send the plaintiff to proper court, or reject the plaint and say that it does not disclose cause of action, so story is over. Very simple. And now I was talking of your query that you will have to memorize things. If you want to memorize anything, you can do it. You are now, see, reservoir of enormous intelligence. So you should not have any kind of underconfidence in yourself that I cannot overpower this entire CPC, which is contained in so many sections and so many orders and so many rules. No, 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 no. You should understand the skeleton of CPC. The thing which I said with you on the first occasion in this class. If you understand the skeleton, here is the head, here is the hand, and here is the chest, and here is the back, here is the stomach. So everything is very clear. I said yesterday, if you remember correctly, Order 7, Rule 1 to 8 basically deals with the now drafting of the plant. And as far as particulars of the plant are concerned, this is given in Order 7, Rule 1. What plant should contain, and then the various ingredients or various clarification. If it is money shoot, exact value. If it is immovable property, description of the property. So there is nothing great in it. I gave you one word if you remember correctly, yesterday's thing. So it is nothing great. Now we are coming to Order 7, Rule 9, because till 8 you discussed yesterday. I just refresh your memory, I marked one word everywhere, particulars in Rule 1, money in Rule 2, now immovable property in Rule 3, representative in Rule 4, defendant's interest and liability in Rule 5. So you can now just develop a method, always do this exercise here and there. 1 was particulars, 2 is money, 3 is immovable. Do this exercise as much as you can do. 4 is representative. Now, one word. I have given you a technology, one word, representative. If you want to memorize, if you want to always fall back upon me that I did not understand, I did not understand, I did not do, or you did not do, again and again complaining, then you will not be able to learn properly. So rather than leaving that, we should adopt positivity and we should try to keep in mind everything. Now 5 you said that defendant's interest and liability. 6 is limitation. Just keep one word in mind. This is easier, I hope. You may not remember everything now. In one go, 7 is relief, is specifically pleaded, and 8 relief founded on separate ground. So grounds, a relief ground. So this was now what is there in your Order 7, Rule 1 to 8. This is particularly important. This is particularly important in writing a plan that you have already learned. Order 6 and Order 7, Rule 1 to 8. Now then we move further and we come to Order 7, Rule 9. Procedure on admitting plan. See how beautiful it is. Either it is admitted or it is written or it is rejected. So this is Order 7, Rule 9. I am not required to memorize. 8 के बाद 9 ही आता. Everybody knows this. Then return of plaint, Order 7, Rule 10. Here is 10A also, 10A and 10B. We will read this just now. Then Order 7, Rule 11, a rejection of plaint. Keep making this kind of pictures at home also, time and again, yourself. So now, when you admit the plaint, what will you do? If I ask you a very simple question, if you admit the plaint, what will you do? What will you do? क्या करेंगे आप? What will you do? क्या करेंगे आप? तो लिखा है, when the court orders that the summons be served on the defendants in the manner provided in Rule 9 of Order 5, it will direct the plaintiff to present as many copies of the plaint. So it clearly says that the moment you admit the plaint, then after admission of plaint, summons should be served. On defendant. There may be multiple defendant also, summons will be served to all of them. Summons be served on the defendant in manner provided in Rule 9 of Order 5. So just see Order 5, Rule 9, what is written. We'll read this summons later on. But just have a glance. Delivery of summons by court. अब कैसे वो delivery होगी वो आपको बताएंगे. Rules are basically description of procedure. These orders are description of procedure. So where the defendant resides within the jurisdiction of court in which suit is instituted or has an agent resident within that jurisdiction who is empowered to accept the service, the summons shall, unless the court otherwise directs, be delivered or sent either to the proper officer to be served by him or one of his subordinates. So we'll see how the court will get this summons served. So obviously the purpose is that the summons should be served on the defendant. How it will be served, that we'll know later on. Section 27, 28, 29 is there in CPC. Section 27, 28, 29 of CPC read with Order 5. We'll see that. Summons shall be served. What I said, Order 5 read with Section 27, 28 and 29. Is this clear? Now, then when it takes a decision to serve the summons, then it says it will direct the plaintiff to present as many copies of the plaint on plain paper as there are defendants. भाई जितने defendants हैं उतनी copies लाओ. This is common sense because the defendant will have to respond to that plaint. So as many copies as defendant. So you are not required to force yourself to memorize. भाई जितने, अब जिसे मुझे आपकी परीक्षा लेनी है, I have to take your test. I have to conduct examination for all of you in a class. So what I will do? I will prepare as many copies of test paper as there are number of students, because everybody has to answer the paper. So on the same logic, plaintiff has to present as many copies of the plaint as the number of defendants. जितने डिफेंडेंट है उतनी कॉपी प्रेजेंट कर दो. Now, along with the requisite fee for service of summons, this is private litigation, this is private suit. So in private suit, the state is not going to spend money. So it is your duty to pay the requisite fees for service of this summons, and it is your duty to present as many copies as number of defendants, so that all defendants should be served a copy of summons with the copy of plaint. So that otherwise what is the purpose of issuing summons here? If you do not give them copy of plaint, then what is the purpose? If you give him copy of plaint, then he will answer the plaint in his written statement. So that is why as many as copies as number, if there are 10 defendants, 10 copies. If there are 5 defendants, 5 copies. So that is another area which we will be discussing about summons etc. later on. Then the second rule says, now this is Rule 10. अब आपको सीखने में आ जाएगा कि बेयर एक्ट को कैसे पढ़ते हैं. अब देखिए अभी तक प्लेंट ड्राफ्टिंग में बेयर एक्ट का रोल थोड़ा कम ही था, बिकॉज प्लेंट ड्राफ्टिंग इज बेसिकली डिपेंडेंट ऑन एक्सपीरियंस. दो देयर आर सर्टेन रूल्स एज आई हैव शेयर्ड विद यू, बट नाउ you will be entering more and more into your Bear Act. I hope all of you have Bear Act with you and you will look into the provisions very, very carefully when I will say, because here there will be meaning of various words which is required to be understood. But it is not difficult, let me tell you at the outset. It's very easy, very simple. भाई रिटर्न करोगे प्लेंट को तो क्या करोगे बताओ आप ही बता दो क्या करोगे. जो जो आपके दिमाग में आइडिया है ना, that is what is done in, I tell you, in this CPC. Nothing great. जो जो आपके दिमाग में आइडिया आएगा ना अभी ये आ रहा होगा प्लेंट को रिटर्न करने में. अब प्लेंट को रिटर्न करोगे आप तो यू विल कॉल द प्लेंटिफ और नॉट टेल मी. प्लेंटिफ को बुलाओगे, प्लेंट पकड़ाओगे, कहोगे भाई ये प्लेंट ले जाओ, इट हैज टू बी प्रेजेंटेड इन दैट कोर्ट. So whenever you return the plaint, I am speaking in both language, Hindi, English. I told you, whenever you return a plaint, then you will call the plaintiff and you will ask him to present it before the proper court. You tell me it will happen or not? The answer is yes. The answer is yes. Because if I am not the proper authority, why should I hear the case? Now then you can say that then in that situation, sir, let us reject it. My dear friend, I have already said, procedural laws are handmaid to justice. It is not master but mistress. It has to serve the justice. It has to serve the interests of the person concerned. So procedural law should not be interpreted in such a way that it does disservice rather than doing service. See, I have presented a plaint before a court and I read in Order 7 Rule 1 that I have to submit the proper court fee, I have to value the suit, I have to present the plaint. Now, if my plaint is rejected at the outset without returning the plaint in Order 7 Rule 10, then I will have to draft the plaint again, I will have to submit the court fees again, and it will also basically result into wasteful expenditure of resources and time. So what is advisable? So here law gives concession to plaintiff. Try to understand the basic philosophy behind the law, and then you will understand the law very simply. So law has given privilege to the plaintiff. Law has given concession to the concerned person. And it says that you can take this plaint from here to the proper court because I am not the proper court. I do not have jurisdiction either due to pecuniary matter or due to territorial region or due to subject matter region. I do not have jurisdiction. So take it to proper court. Now if you ask me a general question, I am going into this law, Order 7 Rule 10, I will be reading that, but just I am telling you this common sense and logic. If I ask you a question, suppose my plaint is improperly presented before a wrong court and this point is noticed at later stage, maybe at appellate stage, maybe at revisional stage, maybe after passing of the decree. Can a plaint be returned or rejected at this stage or not? If a wrong is noticed even later on, it must be corrected in general. So this power belongs even to appellate or revisional court. Try to understand the point. Try to understand the point. I will tell you the nitty-gritties of the things also. But this is what is common sense all about. Let us read Order 7, Rule 10 and let us understand. It says subject to the provisions of Rule 10A. The plaint shall, I am reading Order 7, Rule 10A. No, rather Rule 10 first. Order 7, Rule 10. Subject to the provisions of Rule 10A, the plaint shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted. Explanation: for the removal of doubts, it is hereby declared that a court of appeal or revision may direct, after setting aside the decree passed in a suit, the return of the plaint under this sub-rule. So you understand this, you can understand this very easily. So let us come to return of the plaint. On return of the plaint in your material, CPC material, page, this is chapter 9 of CPC material, plaint, Order 7, I have written return of plaint. Rule 10(1), subject to the provision of Rule 10A, is plaint shall at any stage of the suit. Now, at any stage of the suit. So, plaint can be returned. अब देखो आप बेसिक लॉ हर पे लिखोगे, And this will be your short notes, this will be your law on the point. So you have to be careful and you have to jot down the important relevant points. Plaint can be returned at any stage of the suit. At any stage of the suit. Wherever court finds that it has no jurisdiction to decide the dispute. Now, jurisdiction may be pecuniary, may be territorial, or subject matter jurisdiction. Pecuniary, territorial, or subject matter jurisdiction. Is this clear? So it has to be returned at any stage of the suit. Now, and further this has been prescribed in explanation that appellate and revisional court has same power. Not only trial court, appellate and revisional court has same power as court of first instance. First instance means where you went into the first round or first stage, court of first instance has. Very simple, very simple. Appellate and revisional court has same power as court of first instance. This is very clearly explained in explanation to Rule 10. It says, for the removal of doubts, it is hereby declared that a court of appeal or revision may direct after setting aside the decree. Decree has been set aside, so decree has already been passed. The return of the plaint under this sub-rule. This has been added by 1976 amendment, because when you enforce the law, when you execute the law, then you know the various lacunas of law, various holes in laws. So that is how we have been able to notice that this power has been, this power should have been given to the appellate and revisional court also. So that has been done. So the appellate and revisional court has similar power. Now sub-rule 2 says, order 7, rule 10, sub-rule 1 says return of plaint. Now देखो, you are not required to memorize. Many people will say कितना याद करना पड़ता है. कोई याद करने की जरूरत नहीं है. You must understand. Who will return? When it will return? Who? When? For what? This is, you understood. The appellate court, the trial court and the revisional court, when? At any stage. For what? For presentation to proper court. Now, what is the procedure on return of the plaint? Question. Answer. Order 7, Rule 10, Sub-Rule 2. It says, on returning a plaint, the judge shall endorse. So, judge has a duty. Law has to be written in your own language. You should not now copy the language of the bare provision. Judge has a duty to endorse. Endorse means he has to write basically. Endorse. Now what? Write, sign. What? So it says date of presentation, of plaint, date of return of plaint, name of party presenting, No confusion. And a brief statement of reason. Now, why did you return? When the plaint came to me, when the plaint was returned by me, and who came before me, and brief statement of reason, so that it could be presented to the proper court. Is this clear? So that it could be presented to the proper court. Judge shall on returning plaint endorse the date of presentation and return also, the name of party presenting and the brief reason. Now, why we are writing this date of presentation of plaint? Why we are writing this name of the party presenting? Why we are writing the brief statement of reason? Everything has a reason. Everything has a reasoning behind it. See, this is concession to the plaintiff, as I averred earlier, that he is not required to prepare a fresh plaint and he is not required to pay court fees again. If he has paid here less and the court fee which is to be payable to the other court is more, then he will pay the additional court fee there, nothing else. The court fee which he has paid, that will be adjusted there, it will not go west. So this is privilege to the plaintiff, concession to the plaintiff. कि भाई तुमने कब प्लेंट प्रेजेंट किया, कब हमने प्लेंट रिटर्न किया, who are you who presented the plant before me and why I am returning the plant. All these things have to be mentioned before return of the plant. Is this clear? Is this all right? This will help the plaintiff in getting the relief under limitation law. Section 14 says, if the plaintiff has prosecuted his case in the wrong court, which is due to bona fide mistake on his part, then he will get the concession of that much time. He will be exempted in limitation law for that much time. So this is why date of presentation of plaint and date of return of plaint is very important. Who will get the benefit? Party presenting it. No other person will get the benefit because he is privy to this case, so he will get the benefit. And brief statement of the reason so that your order is in that sense a speaking order and everybody can appreciate why it was returned, why it was returned, how it was returned. So that is necessary. Is this clear? You will get the benefit of section 14 of Limitation Act, and from the date of presentation of plaint till the date of return of the plaint. Now here you must understand that when the plaint is returned to the plaintiff, that is the time which will be taken into calculation in limitation. Suppose a court has ordered return of plaint today and the plaint was returned after few days, so it is not the date of today, it will be date after few days which will be calculated for the purpose of limitation. आपने आदेश तो आज पारित कर दिया, but you gave him plaint after 5 days or few days. So now whether he will get benefit of those 5 days or not, the answer is yes. So when we calculate limitation, we will see the date of presentation and date of return, not order of return, not a date of order of return of the plaint. So you may note down this fact very importantly. For limitation, date of return of plaint, that is when plaint was returned to plaintiff and not order of not date of order of return of plaint. which may have been order तो पहले ही हो गया था, date of order is not relevant. What is relevant? Now, date of return of plaint is relevant. Date of return of plaint is relevant, not order of date of return of plaint is relevant. Order may have been given on 1st January and plaint was returned on 10th January. So it will be 10th January which will be taken into account for the purpose of asking or seeking exemption of limitation. That has to be clear in your mind. That has to be very, very clear in your mind. Let us read the rule further. I hope you understand this. The way यहाँ केस भी लिखा है श्री अमरचंद्र इनानी वर्सेस यूनियन ऑफ इंडिया. The apex court held that where the plaint is returned under Order 7 Rule 10, I am reading the CPC Bear Act, and presented before the court of competent jurisdiction, the plaintiff is entitled to exclude the time during which he prosecuted the suit before the court, having no jurisdiction in view of the provision of Section 14 of the Limitation Act, and by no means it can be held to be a continuation of earlier suit after such presentation. It is not continuation of the suit. Now, the plaintiff is entitled to exclude the time during which he prosecuted the suit before court having no jurisdiction. And it will not be considered a continuation of earlier suit. So, you can write down here further. Sri Amarchand versus Union of India. These cases are not important. I am saying again and again, whenever the case is important, I will let you know. This is just for your reference purpose. The Supreme Court held that plaintiff is entitled to exclude the time elapsed during presentation of suit in wrong court and then presentation of plaint, basically suit, I have written presentation of plaint in court of competent jurisdiction, that is proper court, the court in which the suit should have been filed, वो कोर्ट जिसमें सूट फाइल होना चाहिए था. So plaintiff is entitled to exclusion of time. This is why Section 14 of Limitation Act 1963. Is this clear? Why this Section 14 of Limitation Act? And by no means it can be held to be a continuation of earlier suit. It is not continuation of earlier suit. It is not a continuation of suit. So trial will be conducted de novo. It is not continuation of earlier suit because it is fresh filing of suit. It is not continuation of earlier suit, and even the trial will be conducted afresh. That is called de novo. उसको हम लोग कहते हैं de novo, and that is from the beginning. So trial will commence afresh. Because that was basically a proceeding in a wrong court, not of competent jurisdiction. So what is the relevance of that particular proceeding which has taken place there? So उसका बहुत महत्व नहीं है. Be clear about this. Is this clear? Is this all right? Now, what is the further procedure? What is the further procedure? आप 5 मिनट के लिए रिलैक्स कर लें. I will not take much time. Because it is difficult to continue for long if I do not take break in between. So just take 5 minutes break. Is this all right? So we are discussing the procedure on return of plaint. Now moving further, Rule 10A. After Rule 10, let us read Rule 10A. We are reading Order 7, Rule 10A now. If you are asked any question on return of plaint, whatever you are writing here, that should come in your answer. So answer writing of law is very easy. Now this is blown out of proportion, but this is not very difficult. Generally in answers of law, we have to write the statutory provisions and the case laws. So statutory provision you are discussing and little bit case law here and there, wherever it is necessary. It cannot come at every point. So you should not worry about that at all. Order 7, Rule 10A. So it says power of court to fix a date of appearance in the court where plaint is to be filed after its return. Power of court to fix a date of appearance. अब देखो आपने return तो कर दिया plaint को, but you have got another duty also. One duty was, see, you may be framing a question. When a plaint is returned, what are the different duties of court? So there you can say that the first duty is that endorsement of date of presentation of plaint, date of return of plaint, the party who has presented the plaint, his name should be mentioned. Now all these things has to be mentioned there. But apart from that, what else has to be done? So obviously the court has to inform the plaintiff that, see, I am returning your plaint. Court has to inform the defendant also. The defendant might have come to the court, so it has to intimate the defendant also that, see, I am sending this plaint to the other court. So unless and until you intimate the plaintiff, intimate the defendant how the process will be initiated in that other court. This is common sense. I'll tell you a little bit more, but let us read Rule 10A. This is what is in Rule 10A. So, You saw that the court has duty, first duty of endorsement, date of presentation, date of return, then party presenting, and then the reason for return. The reason for return. Four things. Court has duty to endorse four things. Now, number two, what is the next duty of the court? So you write here, next duty of the court. The other duty of the court, returning the plaint. It says, where in any suit after the defendant has appeared, the court is of opinion that the plaint should be returned. It shall before doing so intimates its decision to the plaintiff. तो कोर्ट अपना निर्णय डिफेंडेंट को तो बता ही रहा है क्योंकि डिफेंडेंट है वो, बट प्लेंटिफ को भी बता रहा है. वेयर intimation is given to the plaintiff under sub-rule 1, the plaintiff may make an application to the court specifying the court in which he proposes to present the plaint after its return, praying that the court may fix a date for appearance of the parties in the said court, and requesting that the notice of the date so fixed may be given to him and to the defendant. So, now court will intimate its decision to plaintiff. Second, court on plaintiff's application. Court on plaintiff's application may specify the proper court in which it should be presented, in which plaint should be presented. This is just very normal and commonsensical. And B, that the court may fix a date for appearance of the parties in proper court. Proper court means the court where the suit should have been filed or where it is being filed now. Requesting that the notice of. Third, this is on plaintiff's application. Now see, within this is point number 2. Within this point number 2, I am writing C now. So, requesting that the notice of fixed may be given to him. Notice to be given to both plaintiff and defendant. Notice to be given to both plaintiff and defendant. Is this clear? Now, then sub-rule 3 says, where an application is made by the plaintiff under sub-rule 2, the court shall, before returning the plaint and notwithstanding that the order of return of plaint was made by it on the ground that it has no jurisdiction to try the suit. Court shall, before returning the plaint and notwithstanding that the order for return was made by it on the ground has no jurisdiction to try the suit, fix a date for appearance of the parties, give to the plaintiff and to the defendant notice of such date. So it has nothing to do with this fact that court has no jurisdiction. Even if court has no jurisdiction, court will do this. So court has been granted a special jurisdiction to do this basic act. So nothing wrong. That is why this clarification. It will fix a date for appearance where the plaint, and it will give notice also. Is this clear? Nothing great here. Then sub-rule 4. When the notice update for appearance is given under sub-rule 3, it shall not be necessary for court in which the plaint. So, if notice is, here you write, if notice is given to both, then there is no necessity to issue summons. Why we have written? Because generally when you accept the plaint, then you issue summons to the other party. Then there is no necessity to issue summons to defendant. See, this is all common sense. Already you have given notice to both parties, so why we will issue summons? There is no necessity to issue summons. Once I have given notice, where is the necessity of issuing summons? It's unnecessary, it's wasteful now exercise, unless the court for reason to be recorded otherwise directs. Unless otherwise. Now what can be otherwise? I tell you. Suppose a plaintiff has filed a case against 3 defendants. 2 are present, 1 is absent. So, the 2 are present and the 2 have been given notice. This 3rd one is missing. So, will you not issue summons to him now? Will this court to whom the plaint is presented now, will it not issue summons to 3rd party, 3rd defendant? The answer is yes. The answer is yes. The absentee defendant will be served summons. Absentee defendant will be served summons. उसको आप समन सर्व करेंगे, क्योंकि वो जानकारी नहीं रखता. He has not information, he has no notice, he has no information. So जिस 3rd defendant को information नहीं है, notice नहीं है, वो क्या करेगा? उसको आप समन्स जारी करेंगे. देखो सब कुछ कॉमन सेंसिकल है. I filed a plaint before a wrong court A against 3 defendants. 2 defendants are present before the court, and I prayed for return of the plaint, and I said to the court, I requested the court, I prayed to the court that you please fix a date of appearance and you please serve a notice on both parties. Court will serve the notice on me and court will serve the notice on 2 defendants who are present before the court. Court will fix a date for appearance of the both parties. But the 3rd defendant is not there. So in such a situation, the court to which it is presented now will issue the summons. It shall not be necessary for the court in which plaint is presented after its return. Can you see sub-rule 4? Sub-rule 4 says, when the plaint is presented to this proper court, then it will not serve summons unless otherwise directs. And the said notice shall be deemed to be a summons for appearance of the defendant. All right. Where the application made by the plaintiff under sub-rule 2 is allowed by the court. आपने जो application दिया उसको court ने, plaintiff shall not be entitled to appeal against the order returning the plaint. Now, is this clear? Plaintiff has no recourse, no remedy in this case, because that is unnecessary. Your prayer has been heard, you have been given relief. Now, rule 10b. ये आपका एप्लीकेशन आया और मैंने उसको सुना और मैंने नोटिस भी सर्व कर दिया, डेट भी फिक्स कर दिया, then why will you file them? If you are aggrieved by court's decision of return of plaint and you think that this is not genuine, court has done wrong, then obviously you can file an appeal. अब बात को समझ गया ना? यदि मुझे लगता है कि कोर्ट ने अपील को, कोर्ट ने हमारे मैटर को रिटर्न, कोर्ट हैज रिटर्न माय प्लेंट व्हिच वाज नॉट एक्सेप्टेबल टू मी, व्हिच इज नॉट एक्सेप्टेबल, व्हिच आई फाइंड टू बी रॉन्ग, व्हिच आई फाउंड टू बी रॉन्ग, so obviously I will appeal against that decision. But where I have prayed to the court and I have asked for this intimation and for this reference to the proper court, then where is your grievance? It has been done by the court has directed you to be present before the proper court, and court has also need to issue notice to both parties. So where is the question of your grievance? So why appeal in such case? You cannot blow both hot and cold. Power of appellate court to transfer suit to proper court. Now this is same as rule 3. This is same as rule 3. Only thing is that it is same as sub rule 3. Only thing is this is power of appellate court. Where on appeal against an order for return of plaint, the court hearing the appeal confirms such order. अब यदि appeal कर दिया आपने, court of appeal may, if the plaintiff by an application so desire. So this is same again. While returning the plaint, direct the plaintiff to file the plaint subject to the provision of Limitation Act in the court in which suit should have been instituted and fix a date for appearance. So same thing is written, in which the plaint is directed to be filed, and when the date is so fixed, it shall not be necessary for court in which plaint is filed to serve the defendant with the summons. So वही बात कह रहा है, ये appellate court कर रही है. This is what is written. Rule 10B deals with the power of appellate court. 10A deals with power of same court where this was plaint was filed. So that is power of trial court, and it is power of appellate court. कभी preliminary में भी सवाल पूछ दे. So rule 10 is power of court of first instance. First instance means where you will go in first stage, that is trial court. So this is trial court and this is appellate court. अब देखो ये भी common sense है. 10A is first so trial, 10B second so appellate. So this is how you can keep these things in mind, nothing great here. So this is procedure on return of the plaint. I have ONGC case on this point, limited versus modern construction This is AIR 2013, Supreme Court, whole citation is not written, sorry for this, but that is not required. In the present case, the court held that once the plaint is presented after being returned from the court having no jurisdiction, it is to be treated as a fresh suit. Even if the trial was conducted earlier, it has to be done de novo. So, you write in your own language, after return of the plaint, it has to be treated as a fresh suit and trial will be conducted de novo, means afresh from very beginning. फिर से आप trial करेंगे. Trial will be conducted de novo. The only protection could be to take advantage of the provision of limitation and court fee paid earlier. The only advantage is protection from bar of limitation. This is number one protection. That is why we are writing that date of presentation of plaint, date of return of plaint, and then the party presenting the plaint and the brief reasons. This is the reason. And the court fee paid earlier. This is a great advantage to the plaintiff, and the court fee paid earlier. So if you have paid any court fee earlier, that will be adjusted. If you have paid the whole court fees, all right. If there is less fee paid, then you will be given that concession of payment of that. This is what is on return of plaint. I hope I have dealt with all point. Now a question arose in a case there have been various questions. एक तो मैंने लिमिटेशन वाला बता दिया, लिमिटेशन स्टार्ट्स फ्रॉम द डेट ऑफ रिटर्न ऑफ प्लेंट, नॉट फ्रॉम द डेट ऑफ ऑर्डर ऑफ रिटर्न ऑफ द प्लेंट. सो बी केयरफुल अबाउट दिस. In many cases, for even returning of the plaint, you are required to read the plaint as a whole. Now, in one case, a question arose that for proper understanding of plaint, plaintiff pleaded that the document should be looked into which I have annexed with my plaint. But other party was already there, the opposite party was already there. He said, no, only plaint averment should be seen. The document should not be seen, and this is the law. On this point, there have been many divergences of opinion earlier, but now it is very clear and categorical after Honorable Apex Court's clarification on the point that either for deciding the question of rejection of plaint or return of plaint or for initiation of action on the basis of plaint, the plaint should be seen as a whole. Now, and when I say plaint should be seen as a whole, you have to see the plaint meaningfully. It should not be formal affair, rather it should be meaningful, intelligent affair, where plaint should be read as a whole. And when I say plaint should be read as a whole, it means that the document has to be seen in that context, and document can be referred for that purpose. Document cannot be considered now a disjoint document. It cannot be considered a disjoint document. So आप प्लेंट पे कोई निर्णय लेने के लिए प्लेंट को भी देखेंगे और डॉक्यूमेंट को भी देखेंगे जो प्लेंट के साथ एनेक्स हुआ है. तो दोनों को देखना होगा, ध्यान रखिएगा. केवल प्लेंट अवर्मेंट्स पे निर्णय नहीं ले सकते, उसके साथ साथ डॉक्यूमेंट्स को भी प्लेंट के देखना जरूरी है. व्हेन आई से प्लेंट शुड बी रेड एज ए होल, इसका मीनिंग ये भी है कि प्लेंट के साथ साथ आप डॉक्यूमेंट को भी देखोगे. अब देखो लॉ में ना देर आर वेरियस डिसीजंस विच चेंजेस द अर्लियर लॉ, सो यू हैव टू बी केयरफुल अबाउट चेंज इन लॉ. That has to be taken care of. I hope you have understood the admission of plaint and return of plaint. Now let us come to this rejection of plaint. Order 7, Rule 11. Very, very important topic. You may raise a question at the outset why there is provision of rejection of plaint, because plaint is initiation of a civil suit. Once the process is initiated on a wrong plaint, then obviously it will consume time of the court. It will consume time of the court and it will put defendant in disadvantage. And obviously it is general understanding and rule of common acceptance that there should be speedy justice and there should be fair trial. So if we initiate action on the basis of wrong plant or plant which does not meet the criteria of plant which does not disclose cause of action, it is going to result into wastage of the time of the court as well as of the party. So no enormous energy and precious time should be wasted. That is why the provision is there that it should be rejected at the outset. If nothing is there, then let us reject it. We'll give you opportunity to amend, correct. But if nothing is found, then it's very difficult. Then it is very difficult. Then it is very, very difficult. Is this clear? We will not allow this kind of action to move further. So to terminate civil action at the threshold without recording evidence and conducting trial, without recording of evidence and conducting trial saves precious time of the court and the system. So we will not record evidence, we will not call the defendant also. See, plaint can be rejected again at various stages, before initiation of trial, during trial and even post-trial. That is not in denial. So before defendant has appeared and whether during trial where defendant is there in the court and even after trial. But if the question is raised of rejection of plaint, it should be decided immediately without moving further, because it will serve no purpose if we move further and if we waste our time, your time, court's time. So this is very solemn provision to that extent. Now you may raise a question, what are the different situations when plaint can be rejected? What are the different prayers which can be raised for rejection of plaint? That can be another question, a very interesting one. So देखिए इस पे व्यवस्था है, बड़ी सिंपल व्यवस्था है यहाँ, एंड सिंपल व्यवस्था इज कि भाई प्लेंट के रिजेक्शन का प्रेयर तो तीन प्रकार से प्रेयर हो सकता है. एक फॉर्मल एप्लीकेशन, एक suo motu court can do on its own because court is saving time, and third is demurrer, where the counsel of defendant without filing formal application will move an oral application. Move oral application to decide maintainability of the suit. So ध्यान दीजिएगा बात पर, मैं अभी आता हूं इस चीज पर, फिर से आपको बताता हूं, but just be careful. तो मैंने आपसे सवाल पूछा, दो सवाल पूछे मैंने बेसिकली आपसे. One question is, what are the different grounds of rejection of plaint and what are the different prayers? What are the different prayers for demurrer? So एक क्वेश्चन बना लें ऐसा, what are the different ways of getting plaint rejected? और सीधा लिखो ना, what are different ways of rejection of plaint rejection? What are different ways of plaint rejection? So answer is, one is formal application, where the party will file an application for this purpose. Then there is suo motu, where the court can initiate its action on its own. Court will do on its own. Court अपने आप करेगा. Formal application, the party, obviously the opposite party, can move a written application. And third, demurrer. 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 An objection. Demurrer means basically an objection. So demurrer refers to situation where the defendants only makes oral request. Defendant makes oral request. He does not file a written application. He does not file a written application. So these are different ways of plaint rejection. These are different ways of plaint rejection. Now sometimes people may think that what is the utility of this class? This is the utility of this class. It is not written in Takwani's book or any book for that matter. If it is written somewhere, I am not aware. So you will have to learn it by way of experience, by way of gathering information from different or various corners. There is ocean of information prevailing, but how this ocean of information can be best utilized for your own purpose, that is what is the art which is required to be learned in this class. Otherwise CPC is ocean. Anybody can read for months and years and he can be more informative than us. But that is not the purpose of this class. Only information sharing is not the purpose. The purpose is to learn the law in proper context and proper manner so that we can produce the best text in answer writing or in answering the objective questions. So that is what is our purpose. हमारा उद्देश्य कुछ अलग है. अब देखिए यदि ये तीन प्रकार से हमारे पास एप्लीकेशन आ गया तो हम रिजेक्शन पे विचार कर सकते हैं. अब अगला सवाल है, I already discussed that in rejection of plaint, अभी हम बार बार उस पर डिस्कशन करेंगे. Can we consider the documents? I have already said yes. So we can frame a question whether the documents appended to plaint can be considered part of plaint for considering rejection of plaint. For considering rejection of plaint. That is the question. Answer is very simple, yes. If you read Order 7, Rule 14, it very clearly says that we have to file this documents. Order 7, Rule 14. Production of document on which plaintiff sues or relies. Where a plaintiff sued upon a document or relied upon document in his possession or power, in support his claim, he shall enter such documents in arrest and shall produce it in court when the plaint is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaint. So what you wrote, where a plaintiff sued upon a document or relied upon document in his possession or power in support of his claim, he shall enter such document and shall produce it in court when the plaint is presented, and shall at the same time deliver the document and a copy thereof to be filed with the plaint. So document is to be filed with the plaint. document is very important ingredient in consideration of plant. So I will say the document, in addition to averments of the plants, have to be considered for initiation of proceeding on the plant, for rejection of the plant, for rejection of plant. Document cannot be left. It is to be considered along with the copy of the plant. Document is a necessary ingredient on which we are going to rely in our proving of material facts. So it is necessarily to be looked into. So there should be no doubt in your mind at all. Now coming to the next question, what are the different grounds of rejection of plant? What are the different grounds for rejection of plant? Now it says the plant shall be rejected. Order 7, Rule 11 says. That plant, I have written it separately, shall be rejected. So it is shall. Plant shall be rejected in following cases. Number 1, where it does not disclose cause of action, first point. A. B. Where the relief claimed is undervalued and plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. Undervaluation of relief. Undervaluation of relief. And no correction of valuation even after granting of time by court. Even after granting of time by court. Even after granting of time by court. Where it does not disclose cause of action, undervaluation of relief, and no correction of valuation even after granting of time by court. Where the relief is properly valued but plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. Written upon paper insufficiently stamped, so you are not paying the proper revenue to the court or revenue to the system. I should So, third, insufficient stamp and no correction again. Even after time is granted. Where suit appears from the statement in the plaint to be barred by any law. We'll discuss this ground separately. E and F, where suit is not filed in duplicate, this was added later on. 99 Amendment 2002, clause E and F as inserted by clause 2 of section 17 of CPC Amendment Act 1999. With effect from 1/7/2002. So now clause E and F is written, plaintiff is not filed in duplicate, and where the plaintiff fails to comply with the provision of Rule 9, that is service of summons. No, Rule 9, no, not service of summons, that is in different context. That is in this context only, a procedure and admitting the plaint. All right. That relates to that, obviously. No worry. So, you have written 6 grounds, just try to understand. I have to give a clarification here. Sometimes law which is written in a statute book is not the law which is practiced in court. Though this amendment has been brought in year 2002, but I must clarify that Order 7, Rule 11, clauses A to D stands on a different footing than E and F. E and F are procedural in character, and Honorable Apex Court in Salem Bar Advocate Association has clarified. I hope you are listening to me carefully. Salem Bar Association case, Supreme Court has clarified the point that clause E and F, even if there is no compliance of clause E and F, it will not have same effect as clause A and D, A to D. So first 4 clauses are substantive in character, whereas the last 2 clauses E and F are procedural in character. What I mean to convey, that they being procedural in character, their effect is not the same, and these are mere clerical and procedural, and it will not result into same effect of rejection of plaint. So on this ground, prima facie you cannot reject the plaint. Salem Bar Advocate Association, this point was clarified. The court will not reject the plaint plainly on these grounds. It is merely procedural. So I write this with clarity. I will quote this Salem Bar again and again. Court will not reject plaint plainly on the ground mentioned in clauses E and F of Order 7, Rule 11. I hope this clarifies the point. You must be very clear on the point. See, this is what will happen when the class will move, the student will evaporate. I have told them especially to attend the class regularly, but I can see absence of at least 100 people from the class today. So, almost 20% students are not in the class today. That's really great. And this is how we are going to become judges of this great country. So, if we are not sincere, how will we get the desired result? I don't know how it will happen. I am not sure about this, how it will happen. I am trying my level best, but I don't know what has happened to my all honorable friends, that they have not joined the class today. What is prevailing in their mind, I am not sure. But I have explained the effect of clause E and F. Provided that the time fixed by the court for correction of the valuation or supplying of the requisite stamp paper shall not be extended unless the court for reasons to be recorded is satisfied that the plaintiff was prevented by any cause of an exceptional nature for correcting the valuation or supplying the requisite stamp paper, as the case may be, within the time fixed by the court, and that refusal to extend such time would cause grave injustice to the plaintiff. So see, this is also amended in 1976. So proviso says, now court will grant time for correction of valuation or supply of stamp paper. But it will not grant extension of time unless there is a exceptional situation. And non-extension of time will result into grave injustice to the plaintiff. So, twin criteria has been suggested. Grave injustice to the plaintiff. Now, what can be exceptional situation, I tell you. Now, this corona crisis is one such example. If plaintiff has not been able to supply the proper fee to the court, proper revenue to the court, and he pleads inability for the time being due to this exceptional situation of grave crisis. So, will as a judge you not grant them extension of time? I hope obviously this is an exceptional situation of grave nature, and it will expect you to come out with the exceptional remedy which is allowed in this proviso. And if you do not do it as a judge, then obviously it will result into grave injustice to the plaintiff. So in such a situation, you will exercise your power. There are various provisions in CPC, section 148 is one of them, where you have been given this enormous authority to exercise your power to meet the ends of justice. And remember always, procedural law is handmaid to justice. So we should not adopt the approach of obstruction. We should rather adopt the attitude of facilitation. And the facilitation will be that you have allowed them exemption, you have allowed them opportunity to correct the error later on. So this is very much required. Now for proper understanding of this rejection of plaint, you are required to understand this different terminology used here. But before I go into different terminology, there are few cases written in your Bayer Act also. Now the question is, what can be the stage of rejection of the plaint? I have already said. What can be the stage of rejection of plaint? You can write down the question yourself. The answer is Salim Bhai, quoted in your Bayer Act versus state of Maharashtra. Salim Bhai versus state of Maharashtra. AIR 2003, Supreme Court 759. It was held that Order 7 Rule 11 that the relevant facts which need to be looked into for deciding an application are the averments in the plaint. So, for rejection of plaint, averment in the plaint should be seen. Obviously, I add along with the documents. What is being said, I tell you, you see the plaint and not defendant's written statement. भाई ये प्लेंट के रिजेक्शन की बात हो रही है, डिफेंडेंट्स रिटन स्टेटमेंट इज नॉट रिक्वायर्ड टू बी लुक्ड इनटू. You are not required to see the papers of the other party and the answer of the other party. You are rejecting the plaint. Whether plaint does disclose cause of action or not, that is to be seen. Whether plaint has some infirmity or not, that is to be seen. It can be pointed out by anyone, by court, by you, by me. Obviously, it will be pointed out by defendant generally. That is why he moves court in two different ways. One is by formal application, another is by demurrer. And court can also look into the plaint and court can also reach to that conclusion. But the question is, what documents have to be seen for reaching to the conclusion? So I said you are required to look into the averments of the plaint along with the documents filed with the plaint. Plaint should be seen as a whole. We are not required to see the written statement of defendant. We are not required to see the other party's argument. We are not required to see the document of the other party. We are required to concentrate on plaint averment and plaint document. This is one point. Salim Bhai. The another, in this case, Salim Bhai itself. The trial court can exercise this power at any stage of the suit. At any stage of the suit. At any stage of the suit. See carefully. Before registering plaint, B. After issuing summons, to the defendant any time before conclusion of trial. at any time before conclusion of trial. The trial court can exercise this power at any stage of the suit. Before registering plaint, after issuing summons, and at any time before conclusion of trial. Then there are further questions. There are further issues and further question which is to be looked into. Now this rejection of plaint, you see certain decisions are there also in your material, and basic question remains on the cause of action. I will come to cause of action, but before I go further, I will quote a decision, very important one. I'll give you further point in this decision. This is case of T. Arivanandam. Wherever you get a case on rejection of plaint, this is a necessary case to be quoted. This is T. Arivanandam versus T.V. Satyapal. So, whenever you get a case or question on rejection of plaint which will come in your examination, it's very important. T. Arivanandam, Arivan, Arivanandam, Nandam तो DM होना चाहिए, Arivanandam, Nandam. But पता नहीं यहाँ लिखा है कुछ, spelling is different. Ariba Indian Dandam. No, I don't think this is correct. I don't know, maybe. This decision has been quoted in many cases which I have sent you in your app also, T. Arivanandam. Decision is, just a minute, hold on my dear friend, I am looking to that citation which is there in another case. I'll be dealing with few cases also, so just let me check. What is the name of the case? This is T. Ariba Danam, Ariba Danam versus T.V. Satyapal. Arivandanam. Arivanandam, we read it Arivanandam versus T.V. Satyapal and another. This is 1977, 4 SCC, page 467. This is here, this is volume number, this is page number, alright. So, in this case of T.V. Arivanandam versus T.V. Satyapal, very important observation which is to be noted and quoted by you in all examination. Be careful. It is to be noted and quoted by you in all examination. The learned Munsif must remember that if on a meaningful, not formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, he should exercise his power under Order 7, Rule 11, CPC, taking care to see that the ground mentioned therein is fulfilled. And if clear drafting has created the illusion, clever drafting. Now, even these sites have not written correct English. This is really pathetic. This is Manupatra. They have not written correct English. They write anything. This is now not acceptable. If clever drafting has created the illusion of cause of action, then he must nip it in the bud. So this is how now it is to be. Now it would be right and proper to exercise power under. So just write on this important observation. Write down this important observation wherever you get a question on order 7, rule 11, this has to come in your answer. The learned Munsif, I am writing this. फिर मैं आपको बताता हूं cause of action पे. Must remember that on meaningful and not formal reading of the Plaint, Plaint always include document. Reading of the Plaint, it is manifestly must remember that on meaningful and not formal reading of Plaint, it is manifestly vexatious and meritless. In the sense of not disclosing clear right to sue, he should reject it. Under order 7, rule 11. Taking care to see that the ground mentioned is fulfilled. And if clever drafting has created illusion of, this is very, very important, has created illusion of I will not write further here, I will write then. If clever drafting has created illusion, so I will write illusion at the top. If clever drafting has created illusion of cause of action, then he must nip it in the bud. It should be stopped at the inception, in the first hearing itself. in the first hearing itself. This pen doesn't want to work right now. It has got exhausted, I hope. An activist judge is an answer to irresponsible lawsuits. So an activist judge in answer to irresponsible lawsuits, and trial court should ensure the bogus litigation should be sought down at the earliest stage. At the earliest stage. Is this clear? Just write down this point. Then I'm going to quote the decisions which I have given you in your app. I'll be quoting those decisions which I have given in your app and I'll be reading further. Now this is what is TV Arivanandam versus TV Satyapal. One of the most important decision on Order 7, Rule 11. It says you, what is the purpose? You see, if you see this judgment, it says learned Munsif must remember that if on a meaningful, not formal reading of Plaint. So what is this meaningful, not formal reading? Whenever you read the Plaint, it is your duty as well as a court that you extract the meaning, you read the substance of the Plaint. It may happen in various situations that the Plaint drafting is poor. It may happen that they have written that they are annexing this thing in annexure A and something in annexure C, but they may put it wrongly and annexure C is written in annexure A and annexure A is written in annexure C. It may happen, because legal literacy is very poor in this country. So it may happen that they have not followed any arrangement. They have not performed their task well. So if plaintiff is poor, illiterate, the lawyer is not up to the mark, should the justice suffer? The answer is no. So that is why we have said it should not be formal reading, it should be meaningful reading. And I have already categorically said that the Plaint should be read along with Plaint averment should be read with document also. Whenever the question of rejection of Plaint comes, then only Plaint averments is not sufficient, you have to see the documents also. Furthermore, the defendant's written statement is not of any use because we are considering the question of rejection of plaint. Obviously, the other party can file application for rejection of plaint, that's a different matter, or court can even initiate action because court should not move on wrong plaint as such. You should not read plaint's one para or one line only. You should read it as a whole to extract the meaning. If you find some substance in the plaint, if you find that nature and object of the civil suit or the plaint is clear, though the wordings are not clear, though the language is not formal, but we can extract out the substance of the statement written there, we can understand the nature of the prayer there, we can understand that what is the crux of the matter in the case, and then it is proper reading. It should be read as a whole. It should not be formal, it should be fair. It should not be cursory, it should be clear reading of the facts, clear reading of the facts of the plaint. Then it says, not formal reading of it is manifestly vexatious and meritless. In many cases it may be meritless in the sense of not disclosing clear right to sue. It does not disclose any cause of action. There is no cause of action. I will read a case before you just now. He should reject it under Order 7, Rule 11. This is his duty. It shall be rejected. Order 7, Rule 11 says it shall be rejected. It is his duty to reject. Taking care to see that the ground mentioned is fulfilled. That is ground mentioned in Order 7, Rule A to D in particular, subclause A to D. And if clever drafting has created the illusion of cause of action which is not there, he must nip it in the bud. An activist judge is answer to irresponsible lawsuits. So if the judge is active, it is the duty of judge to see clearly and carefully reading of the plaint that whether it discloses the cause of action or not. And the trial court should ensure that the bogus litigation, the litigation which is only formal, not fair, which is vexatious, meritless, without any basis, that should be shot down at the earliest. Order 711 is not discretionary, it is mandatory. It is mandatory, it shall be rejected. It shall be rejected. It is mandatory. It is not discretionary, my dear friend, it is mandatory. Now you come to the case, this case itself. This is Shravan Kumar Jaipuriya versus Krishna Nandan Singh. I hope you got this case in your app. Shravan Kumar Jaipuriya, case number 3. The point number 3 loaded in your app. This is Shravan Kumar Jaipuriya. Just a minute, hold on. Shravan Kumar Jaipuriya versus Krishna Nandan Singh. Shravan Kumar Jaipuriya versus Krishna Nandan Singh and another. (2019) decision, Civil Appeal number 6760 of 2019. Now, if you read this case, you see that there is no cause of action in this case. Now, I tell you the story in very brief. He brings the plaint and says that there was division and partition of property, gave every detail related to the property in the plaint. The division was among 3 members. The suit acknowledges that one of the respondent was allotted and became owner of one part, another respondent has become owner of another part. Both have been paying taxes for their share. So what is the fact? partition has been done. देखो मैं फैक्ट को कैसे पढ़ते हैं, यू मस्ट अंडरस्टैंड हाउ फैक्ट इज टू बी रेड. यू आर नॉट रिक्वायर्ड टू गो इनटू nitty-gritty. Partition has been done among three and they have been allotted their share. I'm changing now, see, this is how it is read. They have been allotted their shares, all right? And have been paying taxes for their property. Taxes for their share of property, for their share of property. So A, B, C, suppose there has been partition among them and all three are paying. Grievance and cause of action in the suit is that the one of them had sold his portion to another party. What are the facts? Is this clear? Partition has been done among three members and they have been allotted their shares and have been paying taxes for their share of property. Is this clear? Partition done, share allotted, and they are in possession also and they are paying taxes of their shares as well. Clear? कुछ नहीं है, पार्टीशन हो गया, सबके अपने अपने शेयर मिल गए, तीन लोग थे, सब अपना अपना टैक्स भर रहे हैं प्रॉपर्टी का. प्रॉपर्टी टैक्स इज बीइंग पेड बाय देम, दे हैव देयर ओन. नाउ व्हाट इज द ग्रीवांस? अब कहां से कॉज ऑफ एक्शन आता है? देखिए, आता है नहीं आता है? वन ऑफ देम sold his portion to third party via a sale deed, whatever number is there, this. Now prayer, it is void. This is what is ab initio and inoperative. That is what the plaintiff says. Void, ab initio and inoperative. All right. Says it affects privacy because you have sold the land adjacent to me. Then it also affects right of preemption. Preemption, those who do not know, this is a term in Hindu law, Muslim law, that is personal law. In Muslim law it is called haq sufa, where there is a property which is ancestral one or combined property, ancestral property, combined property, and if one is selling his share to some third party, and then his partner and his co-owner can say that no, you have to sell it to me. The another sharer can say, suppose we are brothers and sisters, A boy, B girl and C boy, we three are suppose in a family, and there is property belonging to all three. I want to sell my share, then you two have right of priority that the property should be sold to you because it's a combined ancestral joint family property. Is this clear? You have got right of priority. You have priority over the outsider buyer that you can always claim in ancestral property. This is what is called right of preemption. यानी पहले प्राप्त करने का अधिकार है आपको, आपको पहले क्रय करने का अधिकार है. You are the having right of first buying. आपको पहले खरीदने का अधिकार है. हम तीसरे आदमी को नहीं, I can't sell the property to outsider. If I sell it, now you have priority right. If you do not buy, then I will sell to third party. But this is related to ancestral property, joint family property. अब ये कहता है कि now this is the region of cause of action. Partition has been done, share has been allotted, the share has been allotted, everybody is allotted his share, there is complete partition. Partition by meets and bounds is there. Partition by meets and bounds समझते हैं जहाँ actual physical division of property हो जाता है. So there is actual physical division of property among these three sharers and they have been allotted their specific share. Clear? Is this all right? and they are separately owning that property and patenting that property and separately paying the taxes also. Now, is it now ancestral property in that sense? No. No. Is it joint family property? No. It is individual property now. It is my property now. It is your property, Miss A, and it is your property, Miss B. So we three are free to sell the property to anyone. So where is the cause of action? कोर्ट ने इस केस में पूछा, देखो इसीलिए पढ़ने में कहीं कहीं आपको दूसरे लॉज का यूज होगा. कोर्ट ने पूछा when the property is already partitioned, shares have been allotted, partition has been by metes and bounds, METES, metes and bounds, BOUNDS. metes and bounds का मतलब होता है कि आपका एक्चुअल फिजिकल डिवीजन ऑफ प्रॉपर्टी हो गया है. हिंदू लॉ में टर्म यूज करते. सो इन सच ए केस देयर इज नो राइट ऑफ प्रायोरिटी, देयर इज नो प्रीएम्पशन इन सच ए केस. When the property is separate and divided, then there is no question of metes, then there is no question of preemption. If it is together, so court ने कहा, Supreme Court said that plaintiff does not disclose any cause of action. No legal right in favor of plaintiff. Court said further, in this context, the other party has ownership, which has the right to exclude and transfer the property in the manner he wants. If I have ownership, I have exclusive right to decide the fate of my property. You can't question my right. And the pleading fails to establish any violation of a statutory right or breach of a contractual obligation which creates an enforceable right in the court of law. So in absence of any such right, plaintiff could not disclose any cause of action and plaintiff is liable to be rejected. Plaintiff is liable to be rejected. So आप लिखेंगे, now question is, does it disclose any cause of action? तो आप लिखो आंसर क्या है. राइट ऑफ प्रियम्पशन. देखो आंसर राइटिंग एंड केस राइटिंग इज वेरी सिंपल इफ यू अंडरस्टैंड. अंडरस्टैंडिंग इज द मेन इशू. right of preemption arises in case of anti-state property, that is ancestral property. Ancestral property. And here the property is partitioned and it has been in exclusive possession and ownership of individuals. So the owner has exclusive right to sell or dispose of his property in the way he wants. And for your information, I must tell you, this person filed, now there are three persons. So he files case or he has a dispute regarding one person selling the property to third person. But he does not have any objection to the other party, the third one, selling it to somebody. He has also sold his share. Out of three, two are selling their share. One had already sold, he did not raise any objection. But he had objection on this person who is selling it to third party. He has also sold it to the, no, one has already sold it to third party, no objection. There is no discussion of the plaint in that. But he has objection regarding the second person selling it to third party because he might have some kind of dispute with him. So is it merit full case? No, it is meritless case. There is no cause of action. You cannot claim if I am owner of some property, if I am not selling it to my brother, my sister, if it is self-acquired property or partitioned property, if I am not selling it to my brother, my sister, can they allege against me? The question is no. I can sell it to anybody. I can gift it to anybody. I can gift it to you. Harshvardhan, I can gift it to you. I can gift it to Sonu. I can gift it to Ayushi. I can gift it to anyone. Nishant. Is this clear? I can gift it to Divyans. I can gift it to anyone. That's my discretion. Because it's my exclusive right, it is my exclusive ownership. So there is no cause of action in such a case. It does not disclose any cause of action. So no case will lie, no relief can be granted. I will stop here for the day. If you have any question, please go ahead and ask right now. But you must understand, you have understood today that if you do not disturb me, then the class will be far better. If you poking your nose every time and then, and if you are raising questions every time and then, the whole class will be disturbed and there will be a kind of confusion in everybody's mind कि कुछ ऐसा अनोखा चीज था. Only you cannot understand when you do not concentrate, I must tell you. आप तभी कोई चीज नहीं समझोगे जब आप कंसंट्रेट नहीं करोगे. जितनी बात मैंने बताई, यू शुड अंडरस्टैंड दैट. इफ यू डू नॉट अंडरस्टैंड, look into yourself. Always don't blame others. You see, this is tendency of a weak person, that we blame always others. If I am not able to make you understand, I will blame you. No, I should blame me, that I have not been able to communicate properly. Is this all right? I hope you enjoyed the class today, and you will keep on enjoying the class if you give me complete peace and tranquility. But you must ask your question if you have any concern, any doubt. I have given you liberty to ask in the group also, 9 to 9:30 in the morning, 9 to 9:30 in the evening, so that I can address it next day. Is this clear? ऐसा कोई लिखा नहीं है ऑर्डर 7 रूल 11 में कि एग्जॉस्टिव है. एग्जॉस्टिव तो आप देखो, सिविल कोर्ट को ऐसे भी इनॉर्मस पावर है, एंड दे हैव सर्टेन इनहेरेंट पावर्स ऑल्सो. Is this clear? So I cannot say that it is exhaustive exactly, but it says that now the plaint must be rejected if these are the grounds. अब तुम अपने मटेरियल की ओर भी जरा देखना, ध्यान देना. रिजेक्शन ऑन अदर ग्राउंड्स भी लिखा है मैंने. पेज 81 को देखो, पेज 81 देखो, लिखा है ना, रिजेक्शन ऑन अदर ग्राउंड्स. On other grounds while it fits defect in the plant. Is this clear? Page 81 of your, मेरे मेटल में पेज 81 में, आपके में कहीं दूसरा भी हो सकता है. This is written in rejection of plant, rejection on other grounds. You can see this. हाँ, बेयर एक्ट में तो है ही है. थोड़ा सा आपको भी ना एफर्ट करना चाहिए. बिफोर रेजिंग ए क्वेश्चन, यू शुड लुक इनटू योर मटेरियल. बेयर एक्ट पूछो, but looking into your Bear Act, your material, I hope you have ambitions Bear Act also. I'll improve it further. I am improving right now this CRPC Bear Act. Is this clear? So I'll improve this also, and read TV Aribanandam. So many people are not in class today. I don't know what has happened to them. I hope that the new students who were there yesterday are there. I hope Nishan, Divyans, all are there. I don't know. Shubham was there also. इनहेरेंट पावर है ना, बहुत सारी इनहेरेंट पावर की चीजें भी है। यदि आपको लगता है ऐसा कुछ है, भाई देखो मेरे चैट बॉक्स से आपका सब क्वेश्चन चला गया, क्वेश्चन हैज गॉन नाउ, चैट बॉक्स इज जीरो, माई चैट बॉक्स क्वेश्चन हैव गॉन, बट व्हाट आई हैव सीन समबडी सेड ऑर्डर 7 रूल 10A का थर्ड पॉइंट, तो आप पढ़ लीजिए। हाँ, आप हमसे पूछे अच्छी बात है, बट आप भी पढ़ के समझ सकते, कुछ नहीं है। वो तो लिखा है यही कि भाई कोर्ट को ज्यूरिसडिक्शन हो नहीं हो, कोर्ट को आप प्रेयर करोगे भाई रिटर्न प्लेंट करते वक्त कि आप हमें नोटिस दे दीजिए और आप डेट फिक्स कर दीजिए, तो कोर्ट डेट फिक्स कर देगा और नोटिस दे देगा। वेदर कोर्ट हैज ज्यूरिसडिक्शन और नॉट, दैट इज नॉट एन इशू। कोर्ट को ज्यूरिसडिक्शन हो नहीं हो, कोर्ट नोटिस इशू कर देगा दोनों पार्टीज को कि देखो भाई हमने प्लेंट रिटर्न करने के लिए अमुक कोर्ट में कह दिया है, नंबर 1, नंबर 2 हमने डेट भी फिक्स कर दिया। यही लिखा है रूल, सब रूल 3 में, देख लीजिए पढ़ के। प्लेंटिफ ने एप्लीकेशन दिया, कोर्ट shall before returning the plant and notwithstanding the order for return of plant was made it on the ground that it has no jurisdiction। उसको सूट को jurisdiction नहीं है, सूट में jurisdiction नहीं है ट्राई करने का, बट ये कार्रवाई करने का, रिटर्निंग ऑफ द प्लेंट, फिक्सिंग द डेट, नोटिसिंग द बोथ पार्टीज, ही हैज गॉट jurisdiction। कोर्ट को ये अधिकार है, कोर्ट वही कर रहा है सब रूल 3 में। इज दिस क्लियर? बेसिकली टाइम फॉर प्रेजेंटिंग अ प्लांट, पढ़ लीजिए सेक्शन 14, जाके घर पे पढ़ लीजिएगा। इसमें यही लिखा है कि ना रिटर्न ऑफ प्लांट से, हाँ बिल्कुल एग्जम्प्टेड होगा, यही लिखा गया, यही पढ़ाया गया है बिल्कुल। जब से प्लांट प्रेजेंट, आप सेक्शन 14 को पढ़िए ना, सेक्शन 14 लिमिटेशन एक्ट को देखिए, यही तो लिखा है कि जितना दिन आपका टाइम वेस्ट हुआ वो आपको हम दे देंगे, डोंट वरी। ठीक है, जब से आपने प्लांट प्रेजेंट किया और जब से आपको प्लांट रिटर्न हुआ, उस बीच का समय आपको हम एग्जाम्प्ट कर देंगे। होना भी चाहिए, होना भी चाहिए। इज दिस क्लियर? होना भी चाहिए। भाई आप फीस पे इतना क्यों पहुंच रहे हो, मुझे समझ में ही नहीं आ रहा। फीस से तो रिलेटेड हमने सवाल आज जुडिशरी में नहीं देखा, आप बार बार फीस पे जा रहे हैं। फीस इतना इंपॉर्टेंट आपके लिए? फीस 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 आपके साथ हुआ है क्या ऐसा? क्लास में आप एडवोकेसी स्किल सीखना चाहते हैं? अरे कोर्ट को बहुत सारे पावर है, इनहेरेंट पावर। यदि कोई पावर कहीं नहीं दिया हुआ है तो इनहेरेंट पावर को यूज कर लीजिएगा, है कि नहीं? यदि कोई गलती होगी, मेरे से कोई गलती होगी, तो भूल सुधार का कोई ना कोई तरीका तो होना है। लॉ इज कॉमन सेंस, कोई चीज नहीं मिलेगा तो मैं तो प्लीड करूंगा इनहेरेंट पावर, आप भी कर सकते हैं। अच्छा जी, और क्या है? व्हाट इज द मीनिंग ऑफ एग्जॉस्टिव सेक्शन? एग्जॉस्टिव सेक्शन, एग्जॉस्टिव का मतलब ये होता है इसमें सारी बातें लिखी हो उससे रिलेटेड। हाँ भाई, न्यूमेरिकल इंस्टीड ऑफ रोमन नंबर, सीधा क्या पूछते रहते हो भाई, इससे क्या फर्क पड़ता है, कुछ भी यूज कर लो। कोई एग्जामिनर ये सब में इंटरेस्टेड नहीं है, एग्जामिनर इज नॉट इंटरेस्ट। हम भी तो लिख रहे हैं यही, आप लिखो ना ऑर्डर 7 रूल 11, क्या हो गया? हम तो यही लिखते हैं बहुत जगह, हम तो लिखते हैं। यस वी कैन राइट, यस सर, यस यस यस। सौरभ गौतम, बड़ा अच्छा, बहुत बढ़िया। एग्जॉस्टिव का मतलब होता है उससे रिलेटेड हर बात लिखी है। जैसे सेक्शन ऑर्डर 7 रूल 11 में ग्राउंड्स एग्जॉस्टिव हैं कि नहीं? तो हाँ, ग्राउंड एग्जॉस्टिव नहीं है, अदर ग्राउंड्स पे भी रिलीफ दिया जा सकता है, रिजेक्शन ऑफ प्लेंट हो सकता है। इज दिस क्लियर? अब आप जजमेंट पढ़ लीजिएगा जो ऐप में मैंने डाला है, प्लीज रीड दिस जजमेंट। आर के रोजा वर्सेस यूएस रायुडू, आपके ऐप में डाला होगा। आर के रोजा वर्सेस यूएस रायुडू एक केस डाला होगा। माधव प्रसाद अग्रवाल वर्सेस एक्सिस बैंक भी डाला है, माधव प्रसाद अग्रवाल वर्सेस एक्सिस बैंक। सो यू रीड दोज डिसीजंस व्हिच इज देयर इन योर ऐप। आई विल स्टार्ट फ्रॉम हियर। अभी प्लेंट में और भी चीजें आएंगी डिस्कशन में। इज दिस क्लियर? Thank you very much. God bless you. Revise your notes carefully. Attend class regularly. Okay, bye-bye. See you then. See you tomorrow on time, please. Thank you very much.